appreciate LACOE's consideration of the issue of expulsion and denials of admission of private school children with disabilities. It is my understanding that SB 1327 broadens the scope of the requirement for private schools to file reports with the county superintendent when the attendance of children with disabilities is severed as a result of actions by the private school. This provision was intended to safeguard children with disabilities from discriminatory action. According to LACOE's guidance, the county superintendent or designee is to examine the reports and draw to the attention of the county board and local boards any cases in which the interest of the child or the welfare of the state may need further examination. The statute states that the County Board of Education may, on its own action, hold hearings on those cases in the manner provided in section 48914 and with the same powers of final decision as therein provided. Clearly, the interests of a child are at issue when that child is denied access to an educational program due to her disability. Clearly, the welfare of the state is at stake when state dollars are used to finance an institution that engages in discriminatory behavior. The private school in question is a recipient of state and federal dollars and as such is prohibited from discriminating on the basis of disability. Allowing such discrimination from private schools sets up a double standard in comparison to public schools who are subjected to strict enforcement. We must not stand by and allow private schools who are benefiting from our public dollars to cherry pick only the high-performing students and exclude children with disabilities from their publicly funded programs. We would never allow such a behavior for a public school, and publicly funded private schools should not be allowed to get away with it. I commend this board for their guidance, LACOE, for their guidance document on SB 1327, and urge this board to conduct further outreach to the private school community so that they can become aware of their obligations under the law. In some cases, as in the case of the Archdiocese of LA, private schools are part of a district-type system, and notification to the parent organization will be a good start that may not be resource-intensive. I would suggest that a starting point would be to direct your staff to research whether or not federal or state dollars are flowing to LACOE to any Archdiocese programs. I also urge you to consider exercising the discretion granted to this board per the Ed Code and hold a hearing for Rita Luce's child. Ms. Luce's child has not had the benefit of having a thorough hearing conducted by an impartial party. LACOE's engagement will send a clear message that the board does not endorse disability-based discrimination and may deter future acts of discrimination by private schools. Thank you.
Thank you very much.